take it slow, but it's not typical. He already
Hey
knows.
guys, welcome back. This is the third video in the Dying Declaration series. If you haven't seen the first two videos, I'll put them in a playlist and they will pop up on the top right corner of your screen right about now. So you can watch them and then you can come back and watch this one. Last week, we spoke about statements which are regarding a circumstance of a transaction leading up to death and how those statements become relevant as dying declarations. Today, we will be discussing statements which are directly regarding a cause of death or a cause of injury. Most of these statements are post-injury and soon after them, death occurs, making these statements dying declarations. Let's understand this concept better with the help of exemplification. So here's an example for you. Imagine there was a lady who was continuously harassed for dowry by her in-laws and the husband. And one day they actually set her on fire.
This girl is on fire. This girl is on fire.
Now this poor lady who the in-laws and the husband tried to burn in order to gain some dowry is rushed to the hospital, where the magistrate comes and takes her statement. In her statement, she tells the magistrate what happened, what the cause of injury was, how the in-laws tried to burn her, so on and so forth. Unfortunately, eventually she dies. Later, this statement which she gave to the magistrate will become relevant under Section 32 Clause 1 and can be utilized by the court while weighing the evidence in the case. Now you can understand how this statement is different from the statement we discussed last week. This statement is regarding the cause of death or the cause of injury and is mostly made after the injury, or it's a post-injury statement, whereas the statements that we discussed last week was regarding the circumstance of a transaction which ultimately leads to death. Now that we've understood the fine difference between these two statements, let's move on. Let's understand what is the evidentiary value of these kind of dying declarations which are regarding the cause of death. The evidentiary value of the dying declaration that we've discussed today is very high if all the right requirements are met. It can even be the sole basis of conviction in a case. Now some of you may ask, what will happen if the person who gave the dying declaration did not die? Can there be any utility to the statement? Let's take the example of the lady again. Now if the lady who gave the statement to the magistrate about how the husband and the husband's family set her on fire, if she had not died and she had actually survived, what would happen to her statement? The answer is yes, her statement would still be relevant. If she doesn't die, she would presumably become a witness in the case against her in-laws, and then her court testimony can be corroborated by her statement which she gave in the hospital to the magistrate. Thus, that statement becomes relevant under Section 157 of the Indian Evidence Act and can be used for corroboration of the court testimony, and hence the statement is used for corroborative purposes. The statement can also be relevant under Section 21 of the Indian Evidence Act. I suggest you read Section 157 and Section 21 from the PAIR Act. Let's see the various aspects of dying declarations which are regarding the cause of death. Now, the dying declarations which are regarding the cause of death can be oral or written. The statement may be made further to either one person or to multiple people. And if the statement is made to multiple people and all those statements which are made to different people, all the statements are consistent, they're same, it can be a very strong piece of evidence. Number 3. If the statement is written, then it has to fulfill certain conditions to be utilized as evidence in a court of law. Let's see what these conditions are. A. It is a best case scenario if the statement is made to a magistrate. It may be made to other people like to a doctor or somebody else, but then the evidentiary value of the statement reduces, and it also requires at least 2 witnesses. However, it is important to mention that it is not optimal for the police officer, especially the investigating officer or the IO, to record a statement. B. Before the statement is recorded by the magistrate, it is very important that the doctor gives a medical certificate certifying that the person is in a position to make a statement, and this is a sine qua non for the relevancy of the dying declaration. C. It is very important that the statement is made in question-answer format and the exact words of the person are recorded or used while recording. However, if the statement is in narrative form, or it is a sum or a crux of what the person who was dying said, it can still be utilized, but the court will have to see the evidentiary value of it and will have to examine the person who took down the statement. So overall, it can be utilized, but it might affect the evidentiary value of the statement. D. It is best if there are at least two witnesses present. E. Lastly, the statement must be signed by the person who made it, without which the court will be very hesitant to use the statement. Any of the above mentioned conditions are not met, as I said before, the court can look into the reason for it and decide whether or not to utilize the dying declaration before coming to a decision in the case. And if the court decides to utilize it, the evidentiary value of the statement will definitely go down a notch. Today, we learned that statements which are directly regarding the cause of death also fall into the category of dying declarations and can be relevant under Section 32, Clause 1 of the Indian Evidence Act. Further, we understood the kind of statements with an example, further analyzed their evidentiary value. We also spoke about what happens if a person survives after giving a dying declaration. And lastly, we discussed the essential conditions for a dying declaration regarding the cause of death to be used by the court as evidence. Next week, we will discuss a case regarding dying declaration to tie a pretty ribbon on this topic. So make sure that you hit the subscribe button before you go.